This is COM 330, video number 3 for access to courts. We are looking at diminishing or preventing rather or diminishing publicity and some things that happen in courts. And this is important because if you decide to cover it as a public relations professional, as a journalist, or as a blogger, these are things that you need to be aware of what is legal and what isn't. And you might actually be referring to these in situations, you might be in a situation where you might have to know this. So it's important to know that judges may try to diminish publicity. Now this conflicts with the right to know, but it has to do with the right to a fair trial, so those can be in conflict. Let's look at 6 ways that judges can stop publicity. The first is gag orders on the media. Sometimes in the past, judges have said you cannot publish any information about this particular case, and that is allowed, as I've said before, in Canada. That's written into some of what they have, but not as prevalent in the United States. A gag order on the media is where a judge tells the media not to report on something. Now, as you might have been thinking, gag orders on the media for a trial are usually not constitutional. There have been a number of cases where they went to the Supreme Court, a judge's order to gag the media, and the Supreme Court said that judges could not do that. Now, that doesn't mean it's totally banned, but it's almost never found to be constitutional. Judges usually don't try to stay away from that. In a past case, the Supreme Court declared that it was prior restraint and violated the First Amendment. So that is one of the precedents that judges look at, and so usually you don't see that. It's pretty rare that you see that, and maybe it is someplace that's not well known or in a small jurisdiction. The second way that judges can try to reduce publicity is restrictions on the trial participants. That could be all kinds of people in the trial, including witnesses. And that is something that a judge is allowed to do. So a judge can issue a gag order for a witness. They can tell a witness not to talk to anybody about the case. Now, that is helpful in a trial because if a witness talks about a case, perhaps another person will hear it and they will corroborate a story that actually isn't true. So that's one of the reasons that they allow that in a trial. Now, the interesting example. Some of you have heard about, you all know Michael Jackson. Some of you have heard about the Michael Jackson trial. There was a documentary that I think was 4 hours long on Netflix. It was out, I think it was on Netflix. Maybe it was Amazon Prime, HBO, I can't remember. One of those. And there was a long documentary about this case where Michael Jackson was accused of child abuse, and it just so happens that the comedian Jay Leno, who actually is still around, he's been retired for a while, but there was a case where Jay Leno had talked to somebody involved in the case and therefore became a witness. Now, Jay Leno was on The Tonight Show. This was before Jimmy Fallon was on it, and interesting case. The judge issued a gag order on Tonight Show host Jay Leno. He said that Leno couldn't joke about the Michael Jackson child abuse case on television, or actually any place. He had a gag order. He put a gag order on a television comedian. And, of course, that didn't sit well with Jay Leno. Jay Leno was actually scheduled to go in and talk to the attorneys and reference the court, but He did not like this, but he was gagged. Everybody was pretty incredulous at the time, so he tried to find a way to get around it. Here's a picture of Michael Jackson, and the young person there was part of that lawsuit and was actually part of the recent documentary. He's grown up and talked about that case. So Leno was a witness at the trial. He wasn't happy with what happened, so since he couldn't joke about it on television, he would bring in guest comedians. He would be talking about other things, and he would say, and now to talk about the Michael Jackson case, and he would bring in another comedian who would spend a minute or two making jokes about the case. So saying, okay, I'm not doing it, but I'm going to bring somebody else on to do it. And this got a lot of attention, and he was kind of getting close to the line, but it showed that that maybe the judge had gone a little too far. So the judge clarified after this was occurring. The judge clarified that Leno could joke about Michael Jackson, but not discuss his own personal testimony. And so he got back and began to make more jokes about that. And yeah, you can still see some of those on YouTube. Now, we're going to look at post-publication sanctions. So this is if you have post-publication is after something's been published. Let's look at two things judges can do. The first is contempt of court. So you say you cover a trial and you say justice was not done, and you put that in your blog. Can you do that? Are you in danger of contempt of court? Well, judges no longer can charge somebody with contempt of court after a trial for criticizing the trial, except in very rare cases if it puts somebody into danger. But these cases were settled long ago, where the court said you can't, it infringes on free speech, it's prior restraint, you can't do that. So in other words, you can write about what you want as long as it's true about a trial after the trial. And it does have to be true. You want to write the truth about that, but as long as it's true, the court says you are allowed to write about that, even if the judge doesn't like it. Number 2, state statutes. That is another possible way to sanction somebody post-publication. Now, states can order police not to reveal information. States can say child services and other places cannot reveal certain kinds of information to the public. They are allowed to do that, or to reporters, proxies for the public. However, they can't order journalists not to do it. Have they tried to do that? Yes, they have. An illustration would be, in fact, I'll have this next here, and I will talk about an illustration would be crimes by those under the age of 18. And when I was a journalist, we would have, somebody would have committed a crime. Usually we would know the name of the person, the age, because you would be talking to somebody and they say, oh, that was John Smith. There, he's 17, and they would give you a lot of information. So usually you would have that information. And in our case, if it was in 99% of the cases, or maybe 100%, but generally we wouldn't. We weren't in a hurry to publish that information either. And if there was a murder and they were talking about it, I think I might have been tempted, but it wasn't against the law for a journalist to discuss that. There were also some cases, in cases of sexual abuse, we would also, or sexual assault, we would also withhold the information, and in some other cases as well. But that was not something that we had to do. That was by law. It was something that, as journalists, we withheld for the privacy and just for our own private ethics. Court closures to the media, when the court is closed to the media. Doesn't happen too much now. In 1980, the Supreme Court ruled the public has a First Amendment right to attend trials. So that has been a precedent that has been established, continues to this day. Now, a judge can close a courtroom in certain cases. It has to be, has to fit certain criteria. usually it's been ruled unconstitutional. And usually it is the freedom of the press is considered an important consideration for that. Now, what about social media in court? Can you tweet in court? Can you go in court? You're very quiet. You have your phone turned down. It's on silent, and they say John Jones has been convicted. So you take out your Twitter and you say John Jones has been convicted of jaywalking. And so this goes out, and you're the first one to have it. Now, can you do that? It's an open question. Sometimes tweeting is banned in a courtroom. Sometimes they may say, okay, we have it on television. You have the audio, you have it on television. Some judges will say, we don't want any social media. And you have to go along with that. So it's important, if you're going to be in that situation, to check first. And despite many rulings, there's no general policy on whether you can tweet in a trial. So how do you know? You have to check with each judge. It varies from court to court. You don't check with the judge. You actually usually just check with the judge, the rules of that particular court, that particular judge. You can do that with a bailiff or somebody else if it's not online. But some places you can definitely tweet, and that's very common. And actually, that's a less disruptive way than reporters running out to be outside the courtroom so they can be the first ones to broadcast it. So it does vary from court to court. That concludes this week's discussion of access to the court.